My father's attorney was reading from a prepared statement about my mental fitness when I noticed Conrad watching me from across the courtroom. He was looking for something specific. He was looking for the moment I would break, the visible crack in my composure that would confirm. For the judge and the two attorneys, and the court reporter, and the three family members seated in the gallery behind him, that his characterization of me was accurate. History of instability, poor financial decisions, emotional volatility inconsistent with the management of personal affairs. I looked back at him steadily. I had a folder on the table in front of me. I had been building what was inside that folder for 6 years. Let me tell you how a father ends up in a courtroom trying to have his own daughter declared mentally unfit. It does not happen suddenly. That is the first thing I want you to understand. It happens the way most things in families happen, gradually. Through the accumulation of small decisions and unchallenged assumptions, and a power dynamic that goes unexamined for long enough that the person who benefits from it begins to believe it is simply the natural order of things. Conrad Vayne founded Vayne Industrial Solutions in 1991. Manufacturing components, regional distribution. A client base built over 30 years through genuine work and strategic relationships, and the specific tenacity of a man who decided in his 30s that he was going to build something that lasted. He did build it, I do not diminish that. The company was real, and the work was real, and the intelligence behind it was real. What was also real, and what Conrad had spent 30 years declining to examine, was the way he had organized his family around the company, not around the people. Around the company and what each person in the family represented to it. My brother Reed was the face. Sales director at 32, tailored suits. The kind of easy social confidence that Conrad had always associated with leadership, because it looked like what leadership looked like in the rooms where Conrad had always done business. Reed was being groomed for succession in the way that golden children are groomed, not through explicit announcement, but through the steady accumulation of access and opportunity and the specific warmth that my father directed at him in every room they occupied together. I was the compliance officer. I had joined Vayne Industrial 6 years ago after 7 years at a regional firm that handled financial regulation work for mid-size manufacturers. I knew the industry. I knew the regulatory landscape. I knew what exposure looked like before it became a problem, and I knew how to address it while it was still addressable. Conrad hired me because I was qualified. He tolerated me because I was useful. He had never, in 6 years, considered me a succession candidate or a significant stakeholder in the company's future. Which was a miscalculation I had not corrected, because correcting it had not yet been necessary. It became necessary 18 months ago. I was reviewing vendor contracts as part of a routine compliance audit when I found the pattern. A series of service agreements, facilities maintenance, logistics consulting, materials procurement, routed through a vendor called Work Solutions, LLC. The agreements were appropriately structured on the surface. The pricing was within market range. The services were documented, but Work Solutions, LLC was owned by Diane Rourke, Conrad's girlfriend of 4 years. The transactions had not been disclosed to the board. They had not been reviewed under the company's conflict of interest policy. They had not been flagged in any financial filing. They were not illegal on their face. A related party transaction is not automatically a breach. But an undisclosed related party transaction between a company founder and his romantic partner, routed through the company's vendor network without board review, was a significant fiduciary problem. It was exactly the kind of thing that creates legal exposure when someone eventually looks at it carefully. I was someone who looked at things carefully. I reported my findings internally through the standard compliance channel. The report was assigned to a senior manager who reported to Conrad. It was buried within 2 weeks. I escalated to the board directly, a right I had under the company's own compliance policy, a policy I had helped draft 4 years earlier. 2 of the 3 board members sided with Conrad. 1 did not. Her name was Margaret Fell, and she had been on the board for 9 years, and she read my full report and asked specific questions. and told me she believed the findings required independent review. Conrad removed me from my compliance role 6 months after my initial report. Restructuring, he called it. He offered me a lateral position, reduced scope, reduced access, reduced everything except the title, which he kept the same because keeping it the same made the demotion harder to challenge formally. I declined the position. I retained an attorney named Patricia Oath, who specialized in corporate governance and shareholder rights, and who had, in the 8 months since I first called her, become familiar with every document in my folder. The conservatorship petition arrived on a Tuesday morning. Conrad's legal strategy was not subtle once you understood what it was for. If he could establish me as mentally unfit, unable to manage my own financial and legal affairs, he could neutralize my standing in any legal action I was pursuing. He could discredit the compliance report by establishing that its author lacked the cognitive reliability to be trusted. He could take control of my financial and legal decisions through a court-appointed conservatorship, which he was petitioning to hold himself. He had commissioned a private psychiatric evaluation. He had paid for it personally. The evaluator had reviewed materials Conrad provided, a selection of documents, communications, and characterizations that I was not shown before the evaluation and had not been invited to respond to. The evaluator's conclusion, based on those materials, was that there was sufficient basis to warrant a formal competency hearing. Conrad had taken that conclusion to a family court judge and filed a petition. The hearing was scheduled for 2 hours. There was a board meeting the following Thursday, at which Conrad intended to use his majority shareholding position to formally table my shareholder derivative action, a separate legal filing I had initiated 2 months earlier, citing the undisclosed related party transactions and the fiduciary breach they represented, and to restructure the board in a way that would remove Margaret Fell. If the conservatorship was granted before Thursday, my standing in the derivative action was compromised. Conrad's Thursday move became significantly easier. I had understood this timeline for 6 weeks. I want to tell you about the equity program. When I joined Vayne Industrial 6 years ago, the company had a standard employee equity participation program, a vesting structure Conrad had established years earlier to attract senior talent. My compliance role qualified me for enrollment. I enrolled without announcement, the way I did most things, and I vested over 4 years. The program delivered 8.3% of Vayne Industrial Solutions into my name through a process Conrad himself had established and signed, and apparently stopped paying attention to the moment the paperwork was filed. 2 years ago, I began purchasing additional shares. I did this through a holding company, Vayne Compliance Holdings LLC, that I established with Patricia's guidance. The purchases were conducted at fair market value, properly documented, entirely legal, and conducted through channels that did not require disclosure to Conrad because they fell below the threshold that would trigger reporting requirements under the company's shareholder agreement. I now held, between the vested equity and the purchase shares, 22.7% of Vayne Industrial Solutions. Conrad held 41%. Outside investors and 2 board members held 18.3%. Reed held 18%. I was the second largest individual shareholder in the company my father was trying to have declared beyond my competence to manage. I had not told Conrad about the holding company purchases. I had not told Reed. I had not told anyone except Patricia, who had structured every transaction and who arrived at the Phoenix family court on the morning of the hearing with a folder that matched mine and a composure I had come to rely on over 8 months of working closely with her. The hearing opened at 9. Conrad's attorney delivered the prepared statement. History of instability, referencing 2 periods in my late 20s when I had experienced anxiety and sought therapy. Presented as evidence of a pattern, rather than as the ordinary experience of a person managing difficult circumstances. Poor financial decisions, referencing a period 4 years ago when I had carried a significant credit card balance. Omitting the context that the balance had been accumulated during a period when I was supporting a family member through a medical crisis and had been paid off in full within 14 months. Emotional volatility, referencing a documented workplace conflict from 3 years ago that had been reviewed internally, found in my favor and formally closed. Each item was real. Each item was presented without context. Each item was selected from a larger set of facts by a man who had paid someone to find the selection most useful to his argument. I sat with my hands flat on the table and listened to all of it. Then Patricia stood up. She requested the court's permission to examine the commissioned evaluator on one specific matter before any additional evidence was entered. The judge permitted it. Patricia asked the evaluator a single question: who commissioned and paid for this evaluation? The evaluator confirmed that Leonard, that Conrad, had commissioned and funded the evaluation personally. Patricia entered the counter-evaluation, conducted by a court-appointed psychologist, requested through standard channels, who had reviewed the same clinical materials and found no basis for a competency challenge. The court-appointed evaluator had also noted, in the body of her report, that the materials provided by the original petitioner represented a selective presentation of the subject's history that was inconsistent with standard clinical assessment protocols. The judge reviewed both documents. Then Patricia placed the second item from our folder on the table and submitted it to the court. The Shareholder Registry of Vayne Industrial Solutions pulled from the Delaware Corporate Filing Database, current as of 30 days prior. Conrad Vayne, 41%. Outside investors and board members, 18.3%. Reed Vayne, 18%. Tessa Vayne and Vayne Compliance Holdings, LLC, 22.7%. The judge looked at the document. Conrad's attorney requested a recess. The judge did not grant it immediately. She asked Patricia to explain the document's relevance to the competency proceeding. Patricia explained it in 4 sentences. The petitioner is asking this court to appoint him as conservator over the financial and legal affairs of his own company's second-largest individual shareholder. The evaluation supporting that petition was commissioned and paid for by the petitioner personally. The petition was filed 2 months after the respondent initiated a shareholder derivative action against the petitioner citing undisclosed related party financial transactions. The court is being asked to grant the petitioner legal authority over the person, who is currently the primary obstacle to his control of a company in which she holds a documented 22.7% ownership stake. The room was quiet. Conrad was looking at the Shareholder Registry document. I watched him look at it. He was a man who had spent 30 years believing he understood the architecture of everything around him: the company, the family, the specific positions of every person in relation to his own. He was looking at a document that revealed a structural element he had not known existed, built quietly over 2 years inside a framework he had created and signed and stopped examining. He looked at me once. I looked back at him. I did not say anything. I did not need to. The judge denied the recess. She reviewed the counter-evaluation and the Shareholder Registry and the disclosed financial relationship between Conrad and the evaluator he had hired. She denied the Conservatorship petition. She noted in her ruling that the petition appeared to be connected to active corporate litigation in a manner that raised concerns about its underlying purpose. Conrad's Thursday board meeting happened. I attended as a 22.7% shareholder with full legal standing and a compliance filing that was now a matter of public court record. Margaret Fell voted against tabling the derivative action. With my shares and Margaret's board position, Conrad did not have the votes to table it cleanly. The action was referred to an independent auditor for formal review. Dan Rourke's transactions with Vayne Industrial were part of that review. Reed called me the following week. He said he had not known about the psychiatric evaluation. He said Conrad had told him the hearing was a routine legal matter related to estate planning. He said he had sat in that gallery believing he was supporting his father through a procedural formality and had understood, approximately 40 minutes into the hearing, that he had been wrong about what he was sitting in. I believed him, not because Reed had always been generous to me. He had not in any consistent way. But because the specific discomfort in his voice was the discomfort of someone confronting a version of their father they had not previously been required to see. That is not a comfortable thing. I had some sympathy for it, even as I understood it did not change anything between us. I told him the derivative action would proceed on its own timeline and that I was not interested in using it as leverage in any family negotiation. He said he understood. We said goodbye. It was the most honest conversation we had ever had. Conrad did not call. I did not expect him to. There is something I have thought about often in the months since that hearing. Conrad had organized his entire strategy around the assumption that I was the person he had decided I was, the compliance officer, the detail person. The daughter who managed things in the background while the real decisions happened elsewhere. He had made a conservatorship filing based on that assumption. He had hired an evaluator, paid for a report, appeared in a courtroom, and asked a judge to remove my legal autonomy, all based on an understanding of who I was that he had formed and never updated. He had never updated it because he had never looked. He had not looked at the equity program enrollment that had been active for 6 years. He had not looked at the holding company purchases that had been building for 2. He had not looked at the shareholder registry that carried my name at 22.7% because he had not considered me a significant enough piece of the company's ownership structure to warrant attention. He had confused invisibility with insignificance. Those are not the same thing. The authority people claim over you and the authority that is actually documented are 2 entirely different things. Conrad had spent years operating on the first kind, the authority of a patriarch, a founder, a man who had decided how things worked and expected that decision to be honored. The second kind lived in a filing cabinet and a Delaware corporate database, and a court record that now included a denied petition and a noted concern about its underlying purpose. One of those kinds of authority holds up in a courtroom, the other does not. I want to ask you something. Have you ever been assigned a role in someone else's story, the unstable one, the difficult one? The one who cannot be trusted with significant things, and stayed quiet about the documentation that said otherwise? I stayed quiet for 6 years, not from passivity, from the understanding that the right moment for documentation is not the moment when you are emotional. It is the moment when the documentation is complete. Mine was complete. If this story stayed with you, if you have ever been underestimated by someone who confused your silence with your ceiling, subscribe to Silent Verdict. Every day we tell the stories of the people who built the folder, and every day the folder is what wins.